The permanent bar is a concept that all immigrants should be familiar with because it is one of the harshest and most unforgiving portions of current immigration law in our country today. In order for possibilities for many immigrants to open up to get permanent residence, the permanent bar will have to be repealed. So let's take a moment to understand what it is, how it operates, and how, if at all, it can come. First, to understand the permanent bar, we have to be familiar with the concept of inadmissibility. Inadmissibility is the condition that prevents a person from obtaining a green card and becoming a permanent resident. And there are numerous grounds of inadmissibility, including criminal convictions, having engaged in alien smuggling, health-related grounds, prior deportations, likely to become a public charge, having links to terrorism, having committed fraud and misrepresentation in connection with your immigration history, and other prior immigration violations, meaning unauthorized entries or stays in the United States. And it's in this last area that the permanent bar comes into play. But first, just to make sure we don't confuse with some other bars that it is similar to, but worse than. For example, there is a 3-year bar that applies to anyone who departs the United States after having been 6 months in the United States with unlawful presence. That's the 3-year bar, and it renders the person inadmissible for 3 years after leaving the U.S. Similarly, there is the 10-year bar, which applies to those who depart the U.S. after having been here for more than 1 year of unlawful presence. The 3-year and the 10-year bars actually do have waivers, however, and you can even apply for these waivers while you're still in the United States and find out whether it'll be granted before you ever have to leave. So in that sense, these bars are more easy to overcome. In contrast, the permanent bar. The only way to overcome the permanent bar is to wait a full 10 years outside the United States before a waiver becomes available. So it's important not to confuse the permanent bar, which requires 10 years outside the United States, with the 3-year and 10-year bars, which have waivers you may have heard of that can be applied for. Just because you waive your 3 and 10-year bars doesn't mean you'll waive your permanent bar. So who does the permanent bar apply to? That, of course, is the most important question. It applies principally to 2 groups of people. Number 1, anyone who entered or attempted to re-enter the United States without being admitted. In other words, without presenting themselves at a point of inspection, and who did so after already accumulating unlawful presence of more than 1 year, and not necessarily one continuous year. It could have been one stay of 4 months and another stay of 8 months. If you add all of your unlawful presence together and get more than a year of it, and then you leave the United States and enter or attempt to re-enter without inspection, that's when the permanent bar applies to you. Second group of people it applies to, anyone who enters or attempts to enter the United States without being admitted after they have been ordered removed from the United States. These people also have the permanent bar upon them. Now, if the permanent bar applies to you, there's almost nothing that you can do to fix your status at that point. You certainly cannot apply for adjustment of status within the United States. Neither can you simply go back to your home country and consular process for a visa, because once you leave, you'll have to wait 10 years before a waiver becomes available under the permanent bar. And again, the provisional waivers that you may have heard of, which do cure the 3-year bar and the 10-year bar, will absolutely not help with the permanent bar. So there are people who win their 3-year or 10-year bar waivers and proceed outside the country thinking that everything is fine because they did not do a full evaluation and realize that the permanent bar applies to them. Bottom line, do not apply for an immigration benefit if the permanent bar applies to you, unless after consultation with an attorney, you find that you have some sort of defense against it. There are, incidentally, a few immigration remedies that can overcome the permanent bar, but they're not the more usual ones. For example, a U visa or an asylum application can be won regardless of the permanent bar. But just about any other family or employment-based method is going to have trouble. So how can you defend yourself against the permanent bar if you have it? Really, the only way is to prove that it actually doesn't apply to you in the first place. And it takes an experienced and knowledgeable attorney to make that kind of determination. But some possible arguments, just to give you an idea, if you can prove that those earlier stays of yours in the United States were not unlawful presence after all, or if you can prove that your departure from the United States does not actually count as an order of removal. Perhaps it was voluntary, or perhaps it was unofficial. You could also attempt to argue that the law of the permanent bar did not apply on the particular date that the events of your case took place, the time of your stay or the time of your entry. You could attempt to argue that your return was not an evasion of admission, that under the law you should be considered to have actually been admitted at that entry. And there are even more obscure and remote possibilities, including various class action settlements that allow certain classes of people who took certain actions at certain times in certain parts of the country to be protected against the permanent bar. For example, the Duran-Gonzalez settlement, which allows some people who are protected by the 245I law to overcome the permanent bar. But unless you belong in one of those class settlement groups, those protections will not apply to you. So as you can see, it's extremely important that anyone applying for an immigration benefit should determine whether the permanent bar applies to them. And if so, if there's an argument that it actually does not apply.